All right, welcome back. Brandon Rhymes here, Consumer Quarterback Show. We're powered by the Platinum MVP team at Keller Williams Realty, PlatinumCoastalElite.com. We've got attorney Frank Miranda in studio with us, FCMLaw.com here. We're going to talk about landlord law, landlord-specific and tenant law, specific performance, and also recent closing and situations that he's had at his law firm. And he is a litigator, so he will go to the courtroom and go in there and represent clients. We got to tell you about one of our partners as well, InnovativeSolarFL.com. Innovative Solar, longtime friend of the program. Solar, as it's coming down in pricing as well. I know a lot of times maybe you've looked at that in the past, but we'd urge you to talk to our friends at InnovativeSolarFL.com. They have residential and commercial systems that they can put on your properties, and the pricing has come down. It's much more reasonable than maybe in the past when you've looked at it. InnovativeSolarFL.com. Let them know the real estate quarterback sent you. Take them up on those special offers and incentives just by mentioning that you're a fan of the Consumer Quarterback Show. All right, we got a hot listing here, 605 Monterey Avenue in Clearwater. This is a Clearwater location, Pinellas County, centrally located. Great opportunity to own real estate with a pool home here, non-evacuation and non-flood zone. 3 bedrooms, 2 bath, 2163 square feet. We have newer hot water heater, roof AC units as well. Circular driveway, large courtyard, and a beautiful pool area here. 3 bedrooms, 2 bath, 605 Monterey Avenue in Clearwater. One of our hot real estate listings from the Platinum MVP team. All right, Burger Road, Lutz, Florida, 3704 Burger Road in Lutz. This is one of my favorite listings now. Beautiful home. We got a mansion for sale, 10,000 square feet, 9 bedrooms, 12 bath, no HOA or CDD. You got an indoor pool area with a full bar and oversized deck, full tennis court, movie, theater, library, sauna, 2 master suites, a grand balcony, and more. 3704 Burger Road in Lutz, Florida. You can see all of our listings online, PlatinumCoastalElite.com. All right, we got attorney Frank Miranda. Welcome back in.
Thanks for having me, Brandon. How you been?
My pleasure. Doing well. Blessed and highly favored. You know, working hard and getting it done, man.
I agree.
Yes, sir.
That's all you do. Roll up your sleeves and go to work.
That's right. That's right. And speaking of that, how many years you been practicing law?
Over 26 years.
Nice. That's awesome.
I know what
man.
you're going to say. I don't look it, right?
No, yeah, not at all. Not at all. You read my mind there, Frank. All right, so let's jump into some of these different cases. I saw a couple videos on social. I thought it was an interesting video that they put together, but it was a Keller Williams agent saying, I think corporate did it out of Texas, but they talked about how what percentage, I think the question was something like, what percentage of leases that you see are favoring the landlord versus the tenant?
100%.
Favoring the landlord.
100%.
Yeah.
Right. I mean, it's your property. You get to make the rules. And so it's going to be 100% in favor of the landlord.
Mm-hmm.
So I don't think I've ever seen one in favor of the tenant.
Right. And what are some clauses that we might want to look out for?
Now we're talking about residential, commercial.
Let's do both. Let's go to both.
You know, from a landlord perspective, obviously what you're trying to do is guard against any possible attack upon the lease, any possible defense for not paying rent. And so you try to set those aside and say, okay, if there is an issue involving what you perceive to be a landlord breach of the agreement, you're still going to have to pay me, and then we can resolve it thereafter.
Right.
Commercial leases are going to be a lot longer. You know, typically, 30 pages if it's a good one.
Wow.
If it's a residential lease, typically longer is better because you're trying to do the same exact thing of defending yourself in the event the tenant comes up with some sort of theory as to why they don't have to pay you rent. Now, I've heard of a lot of different defenses to foreclosures. And, when it comes to foreclosures on a residential side, I only represent landlords. And so I think the leases we put together are pretty solid, and all we ask of the tenant is just don't destroy my property and pay rent, right? Just take care of it.
Yep.
There's some other specific landlords, if you're talking about a person who owns the property or even a small business, they're going to want maybe some additional extras that they don't want to take the risk of having a pet aboard.
Mm-hmm.
I mean, typically if you allow a dog and a dog bites somebody, even though you may not be liable, they're going to sue you anyway. And so you try to have a lot of defenses on the paper.
Yeah.
From not only your tenant, but also potentially third parties. So If the tenant goes out there, for instance, and contracts to have something put into the house that wasn't authorized, a swimming pool, and they don't pay for it, they're going to lien the property.
Yeah.
And so landlords aren't expected to be in the front yard looking at what's going on in their house 24/7. And so it's potential, it's possible that a tenant goes in there, contracts, even though they don't have the ability to do so, does an improvement to the home, doesn't pay for it. That's a problem.
Right.
So we try and think of all possible scenarios, and then we try to shut the door on those scenarios.
Right. And at minimum, you're pushing liability back onto the person that made the bonehead move. Like, hey, I'm renting this house. I can't put a pool in here. I can't contract for a pool. It's not my house.
Right. I mean, that's an extreme example, but I have seen situations where you can't make some of this stuff up. I mean, I'm trying to think of some of the facts now on as I'm sitting here, but some of the things that occur you just cannot make up. All of a sudden there's 15 people living in the house, and
I bet that's a big one. Yeah.
And you don't know who any of them are, and there's allegations from the neighbors that there's criminal activity going on, and you got to have a reason why to throw them out, and that's why the thicker leases typically cover most of the scenarios.
Right. Yeah. That makes a lot of sense. You got a CYA these days, and especially if you're in that position as a landlord. I mean, and I think back to the COVID breakout, the virus that hit the states. Like, look, there was a lot of protections in there, which ended up having where the tenants is like basically, hey, we don't have to pay for X amount of months, and then these landlords are like, man, I counted on that as my income. That's my retirement.
Right. Not only is it their income, but it's also, they have obligations. A lot of these landlords have mortgages.
Exactly.
They got to pay insurance. They got to pay taxes.
Yeah.
And so the COVID situation was a situation that hit landlords hard.
Yeah, absolutely.
Sometimes they had to sell properties they didn't want to sell.
Right. They're forced into a sell. Now you're looking at less potential income, equity being captured, in other words, because you had to kind of rush it to the market. And I bet, the buyers can get a sense of that. Yeah. Why are you selling? That's one of their favorite questions.
Right. How many buyers are going to buy a piece of property with a tenant that you can't get rid of that doesn't pay rent?
Right.
That substantially lowers the value of your property.
Exactly. Yeah. So you're going to be selling at a discount, eating whatever you got to eat just because you don't want to go into foreclosure and have that on your back, on that, your credit score, et cetera.
In some regard, they got a break too because they kind of put the brakes on foreclosures.
Yeah.
And so they caught a little bit of a break too. But at the end of the day, it was probably it's a first in our generation. It's a first in 100 years.
Yeah.
We're going back to Black Plague or whatever it was called. But,
isn't that act of God? Sorry to interject there. Like in these contracts, sometimes it says, what is it? Force majeure, right? Like an act of God. What does that mean, Frank?
You nailed it on the head, right? It's an act of God. It's no one's fault that the contract cannot be abided by either side.
Right.
It's not our fault. And because of that, the contract should just kind of abate, which means it should just sit there. And no one is obligated to do anything until the situation's fixed.
Okay.
No one contemplated that no one could go to work and earn a living.
Right.
Therefore, we can't pay rent. It's not that we don't want to pay rent. We can't pay rent.
Right.
And so it kind of trickles down to the banks, and the banks are like, well, no one contemplated that you won't be able to collect rent, so your mortgage that's due, we can't really collect upon. There's some more cases that have come out recently regarding that's been litigated a lot since the COVID issue. And some of the cases indicate that if you don't specifically have in there, like pandemic or epidemic, then I don't know. It's kind of split how judges kind of decide.
Really?
Yeah.
Well, that's what's very interesting is the precedent. And it reminds me of another scenario back in the day. Remember when the meltdown happened, the 2008 mortgage crisis meltdown?
Yeah, that was terrible.
You had a lot of these so-called loan modification companies popping up, and then you also had a lot of attorneys that were taking retainer funds saying, hey, we can hold off this foreclosure, like foreclosure rescue type situation. Was there ever precedent set where, because I remember there were some arguments about, if the mortgage and the note were biparcated, meaning whenever that money changed hands, these mortgage-backed securities are sold on the secondary market. Was there? My question is, was there ever precedent set where a judge ruled and said, oh well, you can't produce the mortgage, you can't produce, therefore you can't foreclose. This homeowner, basically owns the house now.
Yes, that did happen.
Wow.
Now, that didn't happen a lot, but what that crisis uncovered was how poorly banks really kept their records.
Yeah.
And so the concept of selling mortgages and buying mortgages between banks was not a new concept. It got
Exposed.
accelerated.
Yeah, accelerated.
When that crisis took place, because people were folding, and so people were able to buy large chunks of mortgages, $50 million blocks at a time, for instance. So they would buy these blocks, not knowing if they were good mortgages or bad mortgages sometimes, and they're willing to invest in that, but they're paying a lot less for it.
Yeah.
So if it said $50 million on its face, they were paying probably less than half, way less than half.
Yeah.
And so that's where they're making their profit. And so, yeah, that got exposed. And so what happened is, effectively, when you buy a mortgage from somebody, you can buy a mortgage from today from somebody, a note. And so what happens is, if you don't have a copy of the note, you can't prove the terms of the note. And so the laws have come back to kind of help out lenders fix their problems. And the laws effectively are, let's say there's a 30-year mortgage and you try to foreclose in year 10. You finally got a copy of the note and mortgage 3 years later. They still haven't paid. It's still a new breach, right? Because you still failed to pay when you got possession of it. You can go back before the court and foreclose. And so some of that got corrected, but it did expose the fact that banks were fast and loose with their record keeping.
Wow. Yeah, that's interesting. I remember that was a question I had back then, and because you hear these different stories and you just wonder, like, what's actual truth? What did that actually happen? So then once precedent is set, does that open the door, make it easier for other people to kind of follow that same logic? Yeah,
and to be in all candor, there's been statutes out there even back in 07, 08 that says if you have a copy of the note, you can reestablish it. The banks had nothing. They just made the allegation, this is what I bought. Like, what proof do you have you bought this one? How do you know this one mortgage was in that $50 million bundle?
Right.
Other than your own statement.
Wow.
You have nothing. So that statute's been around a long time, but again, they were so in disregard of because they're doing so much business, they could care less about the back office, and their back office operations were terrible.
Right. Yeah, exactly.
And they just had people signing affidavits that, meant nothing because they were just signing them and signing them and signing them.
Oh, yeah. And even like Wells Fargo, just not that long ago, had a huge multi-million-dollar settlement. I think was it the FTC that I think sued them, and because they were creating those fake accounts.
Oh, Wells Fargo's been popped a lot.
They've been popped a lot. A lot of the big banks have been popped quite a few times, right? I mean, these big players, man.
And in some regard, as a society, we want to trust that companies do the right thing, and the sad thing is they don't.
Right.
And that's why there's mass torts claims, and that's why you hear the advertisements on television to call a lawyer regarding this, that, or the other.
Yep.
And the sad thing is, even though I don't personally like all the advertising, but the fact is that the public needs to be aware of what's going on.
Right.
And how they're being wronged.
Yep.
And it just seems like if everyone played by the rules,
exactly,
it'd be a lot easier.
Yeah, exactly. That's true, man. Absolutely. All right, let's take a quick break there. We're going to come back more with attorney Frank Miranda on the Consumer Quarterback Show, FCM Law, local office right here on Cypress Street. He's got a great staff over there. Stephanie and the staff does an awesome job with any kind of real estate closings, title closings, of course, real estate law, litigation, landlord-tenant law, if you need that. Frank Miranda coming up here on the Consumer Quarterback Show. I want to ask him about specific performance and how that plays out. What that means is like, hey, so look, one side of the contract saying, hey, I'm not going to close. I changed my mind. I want to ask him about that. Also, subject to the mortgage. Hearing a lot about that as well with higher interest rates. So that and more coming up here on the Consumer Quarterback Show, consumerqb.com.
Hey, this is Grant Cardone, and you've been listening to the phenomenal Brandon Rhymes, the Consumer Quarterback Show.
All right, back here in studio with Frank Miranda, attorney Frank Miranda, FCMlaw.com. A couple of hot listings here in Tampa Bay. We like to feature our listings as a strategy to help sellers sell faster for more money. 2817 Gulf City Road in Ruskin. This is a property that we've got, which would be a prime opportunity to build and develop. You got 23 acres on the Little Manatee River at our property at 2817 Gulf City Road in Ruskin. Direct access to the Gulf of Mexico. Can be subdivided, multiple lots here. Great opportunity. Build condos, townhomes, maybe put in a mobile home or RV park. 2817 Gulf City Road in Ruskin. You can see all of our listings online. PlatinumCoastalElite.com.
Buy dirt Find one you can't live without.
All right, so we got Frank Miranda in studio here. I wanted to get to a couple of stories, specific performance. What does that mean, and how likely is that to happen in a real estate disagreement?
Okay, what it means is this. If one party does not perform under the contract, and typically the scenario for specific performance is based upon the premise of one party is selling something to the other party. Typically in this scenario, let's say a house, or let's say a commercial building. And for whatever reason, the seller says, you know what, I changed my mind, I'm not going to sell. And as the buyer, you've done everything you're supposed to do. You've done the deposit. You performed under the contract. You've done everything you're supposed to do. The financing, your money's ready to go, ready to be tendered in exchange for that deed. And the seller informs you, hey, I'm changing my mind. We're not signing anything. What you can do then is you can sue the seller for specific performance, and you can force them to sell the property to you. And that's both in a residential and or commercial setting. And to answer your second question, yes, that is viable, and yes, that does work. A lot of times it's really easy to prove because there'll be a email exchange, excuse me, between realtors, or even the seller directly saying, "I'm not going to close," and there's no viable reason for them not to.
Wow.
And so when that occurs, you certainly can not only sue them, you can file what's called a lis pendens, which actually puts the world on notice that there's a lawsuit involving this property. So anyone that would buy the property after the filing of that document takes it subject to your claim. I have a case exactly like that right now. Actually, I think I'm set for trial in October on that. So get back with me later, and I'll give you a war story about it.
Yeah, there we go. We'll get the conclusion on that. What about this whole idea of selling subject to the mortgage? Because when I hear that, a lot of investors like that idea because, hey, I can buy it at whatever current rate whenever this loan originated versus the higher interest rates right now, 6-7%. A couple of things come into my mind: acceleration clause, due on sale clause. What is a real life scenario of that, or how do you see that play out?
Yeah, so how that plays out actually is genius in the part of the investor, whoever's buying the property, but there's a lot of risk involved for the person selling. And so, for example, let's say the property's worth $200,000. There's a mortgage of $100,000. They'll say, hey, look, I'm going to pay for the equity, but I want you to keep the mortgage in place, and I'll make the mortgage payments on your behalf.
Yeah.
And so you have to trust that the person's going to make those payments and make sure your credit does not get destroyed. That's always a problem. And I've seen where they don't make those payments.
Yeah.
And so the other part that you have to worry about is if the bank finds out about that, they can say, hey, I never agreed to send a mortgage or give a mortgage to a person by the name of buyer.
Yep.
And seller, this mortgage is in your name. I expect my risk to give you that mortgage is not only backed up by the property, but backed up by your credit score, by everything that we liked about you. And so we have the right, since you have now executed a deed over to somebody, to accelerate that note, and it's due today. And so they can foreclose on the property, and everyone kind of gets wiped out.
Yeah. And I remember having a couple of these conversations, and I had a deal that actually closed, and I brought that up. I brought that up specifically to him about that clause. He says, oh, don't worry. We have investors, we have buyers ready to go if that were to happen. And he says, by the way, very rarely happens. I can't remember the specifics on the conversation, but he said, it doesn't really happen, hasn't happened much. But I could see that happening, though.
Probability-wise, if the mortgage payments are being made, I haven't seen a bank accelerate. Doesn't mean they don't have a right to.
Yeah.
But that being said, the downside for you is if they don't make that mortgage payment.
Yeah.
So then they put someone in there, they're collecting rents, and they're not really paying for anything at that point in time. And when the bank figures out that they're going to file foreclosure, you go back to the seller, and they destroy seller's credit. Buyer walks away with a lot of rent they probably should never have gotten, and the seller is in a world of hurt.
Yeah. The way that I would see that playing out is something happens that wasn't planned, some kind of a pipe burst. Now you got issues that need to be corrected, ceiling, the drywall, the repair. So then the investor's like, maybe I'll cut my losses on this one, let them sue me, and then, kind of plan on that not happening. You know what I mean? He may not have the wherewithal to sue me, etc.
Well, nowadays, I think, it's been fueled by all those stations on television about, DIY and let's fix it up and flip it and all those other things. There's so many people in that business now that no matter how bad the property is, there's a buyer for it.
Right.
Now, it may not be the price you want, but there is a buyer for every property out there.
Yep.
Especially in this area.
Yep, in this market.
Yep.
Absolutely. We're talking with attorney Frank Miranda, FCM Law, longtime friend of the Consumer Quarterback Show here. And what else are you seeing out there? What else?
Yeah, I think earlier I was listening to your prior guest, and you guys were talking about, what happens if people don't really perform under the contract. And so, recently in my office, there was an issue where someone had come to the table and they refused to sign. They were trying to hold the deal hostage by saying, hey, we want some money back in return. We did this walkthrough this morning, and there's a laundry list of things that just weren't the same, and contractually you're obligated to maintain the property. And they had their attorney on the phone, and that's the law. I agree with you. That is the law.
Yeah.
At the end of the day, I said, hey, closing date's today. Just realize if you don't sign the paperwork, the price of poker goes up.
Oh, yeah.
And so the deal closed.
Because then what would happen if they didn't close? They would be responsible for the attorney's fees?
Well, they can lose their deposit, which is pretty substantial, and they could lose their case. So if they try to sue for a breach by the seller at that point in time, I don't think they had a leg to stay on. They didn't know inspection. So what are they going to compare these maintenance things, these claims to? Nothing. And so it's a great piece of property. They got a great deal, and it was just I think it was an attempt on behalf of the buyer just to negotiate a few shekels back.
Try to figure out if they had the leverage, who has the leverage there, right?
Leverage means everything.
And it's at the closing table. So,
but when you call them and say, hey, look,
right.
I don't think you really have leverage you think you have.
Exactly. Yeah, exactly. Good point. I like it. That's good stuff. All right, attorney Frank Miranda, check him out online, fcmlaw.com.
Got it.
fcmlaw.com, and you've given out your email in the past as well.
It's Frank at fcmlaw.com, and the office number is 813-254-2637.
All right, good stuff. Frank, always a pleasure.
Yeah, I enjoyed it. Thank you.
My pleasure. All right. Hey, another great show. We talked with Tom Ryberg, DK Mortgage, on the Consumer Quarterback Show. Talked about dual agency, the different types of agency there. And, of course, attorney Frank Miranda, fcmlaw.com. We want you to please go out there and consider committing a random act of kindness. Do something kind for one another. Be a force for good in the community. And follow us online. We'd love to connect with you at Brandon Rhymes1, at CQB Show. And our YouTube channel has over 2,300 videos there, Brandon Rhymes Realty. We'll see you next time. Consumer Quarterback Show, consumerqb.com.
You've been listening to The Consumer Quarterback, Brandon Rhymes. Whether it's real estate, consumer, or financial advice, let Brandon call your next